First Caribbean International Bank, Barbados Limited, and another, Respondents, and Interested Creditors, Appellants, Saint Lucia.
Lord Briggs will hand down the advice of the board in this appeal.
This appeal is about the priority between different classes of creditors of a company in liquidation in Saint Lucia. The company, Sunset Village Incorporated, was formed in 2005 to carry out a residential resort development in Beausejour, Saint Lucia, for which purpose it acquired the relevant site in 2006 and in 2007 borrowed $13.5 million Eastern Caribbean dollars from First Caribbean Bank, secured by a registered first charge over the site and a floating charge over the rest of the company's assets. The first charge qualified as a hypothec under the Civil Code of Saint Lucia. The company sold properties in the development off-plan, that is, before they had been built, to purchasers who had started to make stage payments of the purchase prices to the company by the time that the project collapsed in late 2009. This gave rise to claims by those purchasers for damages for breach of their purchase contracts. A number of them sued the company and obtained judgment in default for damages to be assessed. In September 2011, the bank appointed a Mr. Jordan as receiver under its floating charge. On behalf of the company, he negotiated settlements of the purchasers' claims, as a result of which they obtained consent judgments for damages against the company in 2011 and 2012, which they registered at the Land Registry of Saint Lucia as judicial hypothecs. In June 2012, the company was ordered to be wound up, and Mr. Jordan was appointed liquidator. He sold the development site in late 2012 for $6.5 million, by which time the bank was owed $13 million under its charge, and the purchaser's judgment debts amounted to another $11.3 million. There were also unsecured creditors for a further $8.3 million. Mr. Jordan sought the court's directions as to who should be paid from the proceeds of sale. The judge directed that all creditors should be paid pari passu, that is, equally, after payment of preferential creditors and liquidation expenses. Both the bank and the purchasers appealed. The Court of Appeal decided that the bank should be paid ahead of the purchasers, who therefore stood to get nothing, so they appealed to the board. The board agrees with the Court of Appeal. The Civil Code of Saint Lucia provides in clear terms that hypothecs rank for priority in the liquidation of the debtor in the order in which they are registered. Since the bank's charge was registered first, it has priority over the hypothecs of all the purchasers. But the purchasers argued that they should rank ahead of the bank because, as receiver, Mr. Jordan had incurred personal liability under the settlement of their claims, which he negotiated, and that his liability was a privileged expense pursuant to Articles 1903 and 1969 of the Civil Code, which ranked without the need for registration ahead of any hypothec. The purchasers were, as Mr. Jordan's creditors, entitled to be subrogated to his prior claim. The board, like the Court of Appeal, rejects this argument. Mr. Jordan did not incur any personal liability by participating as receiver on behalf of the company in the negotiation of the settlement of the purchaser's claims. His right of indemnity against the company was not therefore engaged. Even if it had been, it would not have been incurred, quotes, for the common interest of the creditors, end of quotes, as required by Article 1903 as a condition for priority. His role was, as receiver, to serve the interests of the bank. The board will therefore humbly advise Her Majesty that this appeal should be dismissed.
The board will now adjourn.